Welcome back to yet another Sarah Boone video. I must say, if you haven't watched my previous video on the judge, I highly recommend it because I think it does kind of bleed over into what we're going to talk about today. Case law. Now, I am not a lawyer. I'm not an expert on case law. So I personally tried to avoid reading it and citing it and things like that during these cases because maybe I'm misinterpreting it. But in this case, I am going to make an exception for part of this defendant's motion for new trial. I believe we should talk about the case law that is being cited by James Owens because to me, it doesn't seem to actually help. Now, specifically, I'm going to go to a part that I think every single person who has watched this trial or heard about this trial can understand. We are going to go down to, I believe it's argument 3 here. Yes. So, argument 3. The court erred when it denied a motion for new trial due to an emotional outburst in the presence of the jury. Prior to jury deliberations, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. Undersigned counsel timely moved for a mistrial, requesting a new trial. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. Florida appellate courts have held that the failure of the court to grant a curative instruction or a mistrial can result in the necessary of granting a new trial. See Nevergale v. State, see Smith v. State, see Collin v. State. The court is unable to determine if this outburst affected the jury's decision because no inquiry was made. Under controlling precedents, the defendant is entitled to a new trial. So he is arguing that because George's mother cried out in court watching her son get murdered on video, that Sarah Boone deserves a new trial. And that's possible, right? Maybe it's in the case law. And what I'm going to argue is that it is not in the case law. I am going to argue that it is nowhere in the case law and that we are going to look at this case law and you're going to see that for yourself. So let's begin with the first one. This would be Nevergale v. State. Again, probably butchering the name, but let's get down to the important part here. The defendant primarily argues the trial court erred in denying his motion for mistrial after the alleged victim intentionally violated the trial court's clarified order on a motion in limine. The order provided in pertinent part that any testimony regarding law enforcement's efforts to identify the DNA found on the alleged victim's buttocks could only indicate that such efforts were inconclusive. However, during the alleged victim's cross-examination, in response to one of the defense counsel's questions not related to DNA, the alleged victim ended her answer by exclaiming, "You see the DNA results on me, and now you guys say the DNA is not on my butt, but it was on my butt, it was enough." So the argument here that they're making is, we agree with the defendant that the trial erred in denying his motion for mistrial. The alleged victim's comment deprived the defendant of a fair trial, reasonably may have materially contributed to his conviction, and was so harmful or fundamentally tainted as to require a new trial. We also conclude that a curative instruction would not have remedied this violation. We are compelled to reverse and remand for a new trial. So, a witness made an outburst. Not family that couldn't take watching the video in court. A witness made an outburst against instructions by the court. But let's continue. We've got more here. So they also cite Smith v. State. Later in the proceedings, the state called a Dr. Rao, I'm not sure how you pronounce that, to testify to the extent of Cherish's injuries. Dr. Rao explained that she had testified in hundreds of cases as an expert witness, provided her opinion on various potential causes of death. Dr. Rao had performed Cherish's autopsy, been present at the creek when her body was recovered. As Dr. Rao testified, the state introduced 26 pictures of Cherish's autopsy into evidence. Dr. Rao described the injuries on Cherish's scalp, chest, legs, arm, neck, chin, lip, nose, eyes, genitals, and throat. When the prosecutor asked Dr. Rao about Cherish's throat, Dr. Rao stammered slightly and the following exchange occurred. I'm going to show you 2 more photographs of the dissection taken of Cherish Periwinkle's throat. Will you first tell the jury what you saw when you dissected her throat? Dr. Ross says, yes. So what we do is, I'm sorry, I just need a break. Have about 5 minutes. Court, you want a 5-minute break? I think we'll all take a break for 10 minutes. Thank you. The judge dismissed the jury, and defense counsel moved for a mistrial, arguing that her response was so prejudicial that it cannot be cured by any jury instruction. The court denied the motion. After a 10-minute recess, she resumed her testimony without further interruption. The state later called a crime laboratory analyst who testified that Smith's DNA was found on the inside and on and inside Cherich's body. He put the odds at 1 in 35 quintillion that DNA belonged to someone else. The state also produced surveillance footage of Smith leading Cherich from Walmart to his van. During closing arguments, the state at one point said, and from the grave she's crying out to you, Donald Smith raped me, Donald Smith sodomized me, Donald Smith strangled me, every last breath left my body. Counsel for Smith did not object to the statement and indeed presented no closing argument. The jury deliberated for 19 minutes before unanimously finding Smith guilty of kidnapping, sexual battery of a person under 12, and first-degree murder. By special verdict, the jury convicted Smith of both premeditated and felony murder with kidnapping and sexual battery as the underlying felonies. Now, on appeal, Smith raises the 5 claims. The trial court abused its discretion in denying Smith's motion for change of venue. The trial abused its discretion by denying Smith's motion for mistrial during the medical examiner's testimony. The trial court abused its discretion by denying Smith's motion to exclude autopsy photo. The trial court abused its discretion by overruling the objection to the prosecutor's opening statement and committed fundamental error by not granting a mistrial during the prosecutor's closing arguments. The cumulative effort of the errors in this case deprived Smith of a fair trial. We address each claim in turn. So specifically the one we're talking about, the one that we're interested in, is going to obviously be the break that they took. So let's see here. Make sure I find it right. There's change of venue. That's not the one we want. Still change of venue. Still change of venue. Okay, so here it is, the interruption of the testimony. Well, next, Smith argued that the trial court erred in denying his motion for a mistrial on the account of the interruption of Dr. Rao's testimony. While testifying the injuries and Cherich sustained, Dr. paused, took a breath, and asked to take a break. The trial court promptly recessed. Smith contends this pause was tantamount to a breakdown and asserted the only way to cure the disruption was to declare a mistrial. We disagree. We review the denial of a motion for mistrial for abuse and discretion, and mistrial is appropriate only when erred so prejudicial as to vindicate the entire trial. When reviewing a motion for mistrial dealing with emotional outbursts from witnesses, appellate court should defer to trial judges, judgments, and rulings that cannot glean from the record how intense a witness's outburst was. Thomas v. State. So this is why I decided to make this video. They're saying you should defer to the trial judges. And also, this is all about witnesses so far, right? Remember, George's family weren't witnesses; they were family. They were they were victims in this, right? The fact that Dr. Rao took a break during her testimony did not affect the fairness of Smith's trial. The jury saw no outbursts of emotion from its vantage point. It was closer. Okay, so anyway, continue on. And this case is not like the one cited by Smith, where a witness outburst injected into the proceedings a concern for the emotional distress of another significant to distract the jury from its work as a finders of fact. So here, see Collin v. State. So, no, the outburst wasn't enough here, but they bring into Collin v. State, but again, Collin v. State, it says a witness's outburst. And if we go all the way through to the end, because I don't remember what they decided here. Conclusion, affirm judgment of conviction and sentence of death. So I don't know. He cited it, not me. So now we move on to Collin v. State. So this is one that was cited in the previous case. When the state sought to introduce a close-up photo of the victim's vaginal injuries during the mother's testimony, defense counsel objected. At the bench conference on the objection, the defense stipulated to the photo's admissibility, but objected to admitting it through the mother because the photo had previously elicited an emotional outburst from her at a pretrial hearing. So this is a witness, again, who's had a previous outburst with the same piece of evidence. The defense expressed concern that showing the photos of the mother at trial would invoke a similar emotional outburst that would prejudice Colin before the jury, and argued it would be less prejudicial to introduce the photographs during a testimony of the examining physician who took them. Although the trial court noted that the victim's mother had been crying throughout most of the testimony and was pretty upset as it is, the court overruled the defense's objection. The state then presented the photographs to the victim's mother and asked her to identify what was depicted herein. She replied, "It's my daughter's vagina." When the state was publishing the photograph to the jury, the victim's mother stated twice she needed to throw up and then vomited into a trash can, which was provided by a prescient bailiff. The record reflects this occurred in front of the jury box, and within clear view of the jury, the defense moved for a mistrial. After a brief bench conference, the court announced a recess, and the mother was escorted to the restroom. Although the trial court agreed with the defense and expressed its doubts that there was a curative instruction that could adequately address this incident, it ultimately denied the defense's motion for mistrial. This was error. So they decided that this was enough for a mistrial, okay? In this case, the court clearly reflects the severity and intensity of the mother's reaction to the photograph. Although the state claimed at trial it did not show the mother the photograph in order to elicit an emotional response, we fail to see any other justification for its chosen trial tactic. The trial court was aware of the mother's prior emotional reaction to the same graphic photo, and the defense stipulated to admission of the photograph through a dispassionate witness. The known prejudice of admitting this photo through the mother outweighed any alleged probative value. Accordingly, the trial court erred when it allowed the state to admit the photograph through the mother over the defense's objections. We have found no cases that involve a particular emotional outburst at issue in the present case. The case cited by the state are factually distinguishable from the present cases. Affirming denial of a motion for mistrial where the witness suffered an emotional breakdown after the state asked her to identify the defendants at trial by standing next to them. Affirming the denial of a motion for mistrial when the witness cried throughout her testimony and called the defendant a murderer and son of a bitch in Spanish after being surveyed by the trial court. Jurors confirmed they could disregard the outburst. We recognize there was no bright line rule in cases involving an emotional outburst from a witness. However, in this case, the state's evidence of guilt was very limited, and the court was put on notice of a probable emotional outburst by the mother. Based on these facts, the mother's visceral reaction to the photograph warranted a new trial. The trial court abused its discretion, denying Collins' motion for a mistrial, accordingly reversed his conviction and sentence and remand for a new trial. So the only connection this has to Sarah Boone is it involves the mother, right? George's mother. But she was not a witness. She was not up there. She was in the audience. She was watching, right? None of these cases cited by Owens here are the same. None of them. None of these are comparable to what happened in this case. Now, there's others, and I know people have dug into the others. I've had people in my comments say, hey, if you go into all of these citations, these case laws, none of them really match. But I think this one here is the one that upset a lot of people. The fact that this was even tried, it seemed to actually upset the prosecution in the case, if I'm going to be honest, that they even tried this. And they included it here. I want to be honest. I wonder if Sarah Boone herself asked for this one and gave these case law. It's hard for me, and maybe I just haven't watched enough trials and read enough of these. It seems so odd to me that an actual lawyer would cite what we just read in this situation, because they know it's wrong. It doesn't match. None of it matches. Was it Sarah? I've been wondering that since the outburst happened as well. Was the entire, we need a new trial for that, was that Sarah again, basically demanding it of Owens and Owens giving in? Because that's a very Sarah thing, in my opinion. But other people have gone through it. There's a lot of other case laws you can see here for the continuance stuff, which I I will say I don't remember which lawyer it was. It was something that came up on my feed. I'd say probably almost 2 weeks ago, maybe 2 weeks ago. Whenever this came out, they read these, and they read all these citations for argument 2, and I don't think any of them match the situation at all. And if you haven't watched my previous video on the judge, it's very important that the case law matches as close as possible. He has literally taught people when it comes to, how to argue in court. So he's going to be very particular when it comes to these arguments, which he should. Again, definitely watch that video if you haven't. It really gives you some insight. And of course, we have this one here, which, again, there's a bunch of case law. Let's see here. They actually cite what the case law is. So here's another thing that makes me interested is, so here he just lists off a bunch of case law, right? This is like, blew it out on the page. Here, it's like, okay, here's the case law, and here's how we think it affects, right? So, like here, moreover, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. And then they give for that exact one, we have case law. When a witness is asked to express an opinion that applies the legal standard to a set of facts, the opinion testimony is generally inadmissible. Again, exact case law. Section 9703 does not permit a witness to testify to a legal conclusion or express an opinion upon questions of substantive law. Again, a full section here. Exact case law. Testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury herein. And again, exact case law. And I haven't checked, but I would assume that maybe these do match what he's saying, but not applicable to this situation because of how it actually unfolded in the actual court. Now, with all that said, what is next? What is up? What is going on? Well, 2 days from now, from recording, is going to be Thanksgiving, and my plans have completely exploded. But that's still good news for me because tomorrow I've got a video game launch that is once a year. I'm going to enjoy it. I'm going to just dive into it for hours and hours and hours, and I plan to do that for a while. It's going to be my vacation. Let's put it that way. It doesn't mean there won't be videos, but there may be less. Generally, right now, I'm going to be honest with you. I check the Sarah Boone docket probably 3 times a day. I normally check it when I get up, just in case. I check it in the middle of the day, just in case. And I check it before bed, just in case, because I have had instances where I wake up to Sarah Boone filings. I've had instances where in the middle of the day something pops up, and I've had instances where I am in bed and I check it and there's an update. So that's the timing I check. I still do it out of habit. We're still waiting for that sentencing, so I think I might as well keep checking just in case her and Owens have a blow up and it gets posted on the docket. I'm sure if that happens, I wanna read it. I want to read it as soon as possible. So don't expect as many videos in the next coming days for that reason. Hopefully everyone has a good Thanksgiving. Trying to think of anything else. There's not like any cases I would say that I'm planning to cover at this moment. Not that I'm not interested in ideas, but at this very, very moment, I can't think of any. I think I've at least mentioned or covered all the ones that I was thinking of. Yeah, I did like 2 or 3 hours last night trying to find something that clicked that I would want to cover. Like there's some cases that I could cover, but the circumstances of the cases and things like that just aren't the best. I'll give you an example actually, for anyone that stuck around. There's a new case that I came across, that I stumbled across last night, I want to say. I might look at it in my just out of curiosity if I remember, but I'm not currently planning to do a video. I might. I'll see how the case unfolds. Begin with, it involves a 17-year-old who there was a language barrier, and the call involved burying a body. And they get there and they found it was a dead baby. And normally that's not something I would dive into too much. But the police were asked for, how do I want to word this? The police were asked for more information of what actually occurred, because this is, it was in Georgia, so you have, there's going to be the abortion topics and things like that, unwanted pregnancy leading to, situations, right? Possibly is that the case? We don't know. The person doing the press conference in law enforcement basically said that they won't give more details. Because they are graphic and disturbing, something along those lines. But it is written into the affidavit because they had to, get a warrant and all that, and had to present it to a judge, and basically warned for looking at it, and essentially said, it's up to your networks to decide what you air. So, yeah, like that. I heard that, and I'm like, morbid curiosity. I tried to find it immediately, and it wasn't online. It might be by now. I don't think that's something I'll cover. A lot of cases like that, right? A lot of cases where it's just depressing. It's going to be depressing. I don't know if I want to do that for I don't know if I want to cover that, right, extensively and through the trial or anything like that. So, we'll see, right? We'll see what's next. I right now I'm just focused on my plans for that game and planning out my route and just enjoying myself for the holiday through that game. That's currently the plan. I don't have like anything planned for December, by the way, other than Sarah Boone. Sarah Boone's case, get that sentencing done, and then I am completely out of ideas, which is not good considering December. Well, October, November, December are like the most. They're some of the most views on YouTube and some of the highest like ad revenue and all that stuff. And I'm gonna be honest, I am just like, I think I'm just out of true crime content ideas at this moment. Maybe some stuff that's like more edited. I feel like if I do like older cases and I'm not like, I feel like if I'm doing older cases and I'm not like, almost live reacting, following, I feel like it should be a little more edited, a little more structured. So maybe I'll do that for some older cases. When I have the time, possibility. Might follow the kind of gonna be an might follow the InfoWars, the Onion lawsuit fight thing. If you don't know what that is, basically, the Sandy Hook families work with a satire news station called the Onion, and they put in a bid together, essentially, or the families were willing to accept a lower value for the Onion, and they get like from the Onion, and they get like ad revenue. So that was like ad placements for their charity or whatever. So basically, it was a better deal than Alex Jones's friends. So now, Elon Musk is trying to get involved, and they're claiming it was all illegal. But from what I can tell, and from what lawyers online can tell, this was a legal sale. Like, the auction was legal, the way it was handled was legal in that state. And the only reason I'm thinking about covering it is because it involves Alex Jones, and who knows what that man will start claiming in court. He is a man who, it's not exactly what happened, but it's pretty close. He was asked, I think it was during child custody stuff, or divorce. He was asked about the lives of his children at one point, and he couldn't remember and try very certain details of their lives, and he tried to blame it on having a spicy bowl of chili. So that could be a very comical court appearances, trial documents, and everything, but we'll see. Other than that, I'm kind of open. It's not saying there's nothing I would cover, right? But it's kind of my I don't have anything set in stone or plans. I have like a little document, by the way, that I'll like keep ideas, and then I'll like get rid of it after I go through it or decide I want to do it or not, and it's blank. So that's kind of what the ending of this has been. That's why it's kind of been so long. If you have ideas for stuff, just stuff, for this channel, let me know in the comments. Now, like my other channel, I'm probably going to do some videos on the game I'm going to play. I still haven't done any videos on this game, but I'm really wanting to. I've played it, but been a lot of distractions. You know how things go. I'm gonna play this game, and then I sit down to play it, and then the heating in my home stops working, and then there goes your day, right? You know what I mean? So I have that stuff planned for the other channel, the gaming channel, but this channel I do want to keep, content. I really enjoyed covering Sarah Boone. I found that fascinating, and I know there's some more trials picking up like after the holidays, and I mean like Christmas. Very interested in those. Definitely want to do that. So this is kind of been like a mix-up video of just like a look back. I've already covered this, but I thought it was interesting, to talk about the case law and how it doesn't make sense, and just kind of talk a little bit about plans going forward, how I'm out of plans right now for the next month, right? And we'll see where it goes. Just I don't want anyone thinking, Thanksgiving night there's probably going to be like a long Sarah Boone video, because I just want to say, if Sarah Boone on Thanksgiving, maybe even the day after Thanksgiving, if she submits a 100-page handwritten document about how James Owens has completely screwed her over, I'm probably not going to know about it until the weekend, right? just putting it out there. But expect a reaction when I get a chance. See y'all later. Hope you enjoy the video. If you did, like, comment, subscribe. As I said, the judge stuff is a previous video in the playlist. I know all my content isn't everyone's cup of tea, but I cover a lot of random stuff on this channel. Last week there's been, well, a lot of people don't, no, I wouldn't say a lot of people. Some people don't agree with my opinions on raw milk, but probably a good idea that that, it's coming into milk is getting bird flu. If you're doing raw milk, just, a lot of people don't agree with me politically and still end up watching my content because it can still be informative, but we'll see. It's weird. Well, can I just say how weird it is that pasteurization is in some places, not everywhere in America, but in like select areas, is a political issue? Because I know in California, it's a political issue, kind of with like the hippie left, right? But then in like Pennsylvania, it's more like Amish farmers, type, and like certain conservative groups. Just it's weird. It's a weird mix. Don't drink raw milk. Just it's not worth the risk. Not worth the risk. That's my opinion on it. Not worth the risk. Anyway, maybe Sarah Boone will mention it. Maybe she'll complain that all of her milk in prison is pasteurized. All right, that's. Oh gee, it's been a long video. I'm probably gonna premiere this one because it's so long. So but yeah, any ideas you have for me to cover with like cases, I suggest you put it in the comments below. If you're in the live chat, because if you put it in the live chat, I might not see it. It might go past. I might be away. Bottom, I'll check. I read most of the comments. Well, I read all of them for a certain amount of time, but then of course, there's other videos and stuff. So, and if you see someone down in the comments saying a case you think that would be really good to cover, add a little thumbs up and a heart to it so I can see it.